area, well-known media host out of the Madison, Milwaukee, Green Bay media market, widely listened to. They were shadow banned on Twitter. There's some very prominent doctors in the area that didn't agree, perhaps, with everything CDC or NIH said, that were banned on Twitter. I'd like you to comment on that because, normally I think when people make a major health decision, they always like to get two separate opinions. And some of these doctors who are wildly well respected, probably two of the most prominent doctors in Wisconsin, thought outside the mainstream. And I think for thinking outside the mainstream, they were taken off your platform. Could you comment on why you would take somebody off a platform, or why a distinguished doctor would be considered something that the public as a whole couldn't hear their version of events? Oh, you're not aware that ever any doctors who commented outside the mainstream version of what was going on with COVID, going on with the vaccine, going on with treatments, that there were people who disagreed with the NIH recommendations and you took them off of Twitter? You're not familiar with that? None of you are familiar with that. Okay. I'll yield some time to Jim Jordan then.
I thank the gentleman for yielding. Mr. Baker, Mr. Roth earlier said he thought it was a waste of time for the FBI to be sending you accounts that they thought violated Twitter's terms of services and Twitter's policy. I was just curious, did you ever tell Twitter executives or FBI acquaintances that the FBI had no legitimate interest in enforcement of Twitter's policy?
Sir, I'm going to give you the same answer I gave before. I think the advice that I was giving internally to folks would be covered by the attorney-client privilege. And as
let me
yes,
stop, Mr. Baker. Although you're testified today by subpoena, you nonetheless have raised the attorney-client privilege to avoid answering this committee's question. Congress does not recognize the common law attorney-client privilege. With that, I'm going to allow Mr. Jordan to ask the question again.
Well, there's been two questions I've asked that he's refused to answer. So let me, if I could, Mr. Chairman, I'll ask both again. I'll go back to the one asked a couple minutes ago. Top of page 2 of your testimony, you said, quote, "I did not destroy or improperly suppress any documents at Twitter regarding information important to the public dialogue." I would like to know what you're referring to that you, in your mind, properly suppressed, and when that took place, specifically if it took place during the time that the Twitter files were first being released just a few months ago.
well, again, sir, as I think we've notified the committee and we've had these conversations with Twitter as well to try to resolve this issue prior to coming up here today, I don't have anything in writing that clears me in my ethical responsibilities to my former client with respect to answering questions that I think fall squarely within the attorney-client privilege. So unfortunately, I don't think I can go beyond what I've said there already, sir.
Unfortunately, Mr. Baker, your assertion that the attorney-client privilege, it's overruled as to this particular question and answer. So will you please answer the question by Mr. Jordan?
Point of order. Mr. Chairman.
State your point.
Well, as I understand it, because we just went through this in the January 6th committee, where multiple witnesses asserted attorney-client privilege, including people who weren't covered by it at all. Ultimately, that's for a court to decide. So I don't think there's anything we can do within the committee at this point, unless I'm missing something.
We'll give you one more chance to answer the question. If you don't answer it, then we'll have to deal with it after the committee hearing. Mr.
Yeah,
Baker, could you
yes,
answer
sir.
the question,
I
please?
apologize, but I believe I have ethical responsibilities to my former client, and I don't think I can go beyond what I've said already, unfortunately.
Yeah, I just said that. I just said that. I'm gonna,
Mr. Baker, you did suppress documents then that, in your language, was important to the public dialogue?
I'm going to give you an extra minute, Mr. Goldman.
Oh,
You're
thank you
next.
very much.
I'm sorry, sir, could you repeat the question?
Again, going on what your written testimony. So you did suppress documents at Twitter regarding information that was important to the public dialogue. That's a yes or no.
I'm going to answer the question with the following sentence, which is right after that. At all times, I sought to help my client understand and comply with its legal obligations.
Gentlemen's time's expired. I recognize Mr. Goldman for 6 minutes.
Thank you, Mr. Chairman. I understand that Mr. Palmer was asking some questions about some of my assertions about the removal of the Ukrainian prosecutor general. First, let's be clear. I did not say that Vice President Biden fired Mr. Shokin. It was official U.S. and European policy to encourage Ukraine to fire him, which they did. But he is right about one thing. What I say is not evidence, and neither is what any of our Republican colleagues say on the other side of the aisle. They may not like what these witnesses say, but the testimony of the witnesses is the evidence, not baseless statements without firsthand knowledge. But I urge Mr. Palmer, if he wants to understand what actually happened, to read the 300-page report that we published on the first impeachment investigation. There's a lot in there about Mr. Shokin. Luckily, though, he doesn't even have to do that. You can just read the New York Post story itself. Because in that story, Shokin admitted that he never opened an investigation into Burisma. He claims to have had, quote, specific plans to do so. Yeah, sure. For 2 years, Rudy Giuliani had been peddling Victor Shokin's bogus story, including with agents of Russian intelligence. And Chairman Comer, if you question that, I urge you to look up Andrei Derkach. So who was the sole source of the hard drive to the New York Post? Rudy Giuliani. And for these reasons, many journalists were highly skeptical. One reporter at the New York Post itself refused to put his name on the story. Fox News's Brett Baer said, quote, "The whole thing is sketchy," unquote. And both Giuliani and the Post refused to give the laptop to other journalists to verify and analyze it. In fact, Giuliani told the New York Times that he hoped that it would be published before it could be verified. So what is the so-called authentication for this laptop? Well, Chairman Comer said in his opening statement that it's a subpoena to the computer repair shop owner, which happened over about a year before the New York Post story. But that is not the same hard drive that Rudy Giuliani received months later from that repair shop owner and passed along to the New York Post after he was in possession of it for several months. Now, Mr. Baker, based on your understanding of Russian malign influence campaigns, does Russian intelligence have the capacity to manipulate a hard drive?
Yes.
So it is possible that some of the materials on a hard drive could be authentic, and some could be altered, manipulated, or even added to the hard drive. Is that right?
I believe so, yes.
Mr. Roth, you have testified Andre Derkach. So who was the sole source of the hard drive to the New York Post? Rudy Giuliani. And for these reasons, many journalists were highly skeptical. One reporter at the New York Post itself I yield back.
Chair recognizes Mr. Higgins for 5.
Thank you, Mr. Chairman. I'm going to be yielding some time to my colleague. Knew it would hurt the Biden campaign. So the FBI used its relationship with Twitter to suppress criminal evidence being revealed about Joe Biden 1 month before the 2020 elections. You, ladies and gentlemen, interfered with the United States of America 2020 presidential election, knowingly and willingly. That's the bad news. It's going to get worse because this is the investigation part. Later comes the arrest part. Your attorneys are familiar with that. Mr. Chairman, I'd like to spend 5 hours with these ladies and gentlemen during depositions surely yet to come. But for right now, I'll yield the balance of my time to my colleague, Mr. Jordan.
I thank the gentleman for yielding. I think he made the right point. And I would just respond to to our colleague from New York. You know who knew the laptop was real? Was the FBI. They had it for, or maybe they had it for a year and just said, you know what, we're going to put it on the shelf, we're not going to look at it. But if anyone knew it was real, it's them. That's why I asked the question, again, back to my colleague from New York, what he was talking about. That's why I asked the question earlier. I said, did anyone at the FBI, Mr. Baker, know, did Mr. Baker talk to any of those 51 former intel officials who sent the letters saying this has all the classic earmarks of a Russian misinformation operation? Maybe they could have checked with the FBI because the FBI had the actual laptop in their possession. So I appreciate the gentleman from Louisiana. I think it's a great point that he made. Mr. Roth, I'm going to come back to you on something we were at a few hours ago. And we're talking about this visibility filtering, which in my mind I understand to be something short of suspending and blocking the account, which the user then knows has happened because there's a notification in a public way, like you did to Ms. Green when you suspended her account. But there's other things, this search blacklist, this do not amplify, that are some kind of filtering that account that the user doesn't know about. And I asked the question earlier, was there any bit of this visibility filtering that was hard-coded by Twitter employees into the account of specific users? And you said, you hesitated for a while, and you said, well, you wouldn't use the term hard-coded, but it seemed to me like something like that went on. Can you elaborate?
Thank you for the question. Twitter's visibility filtering system, as has been reported in the Twitter files, is based on applying labels to user accounts. And so in that sense, if the application of a label is what you meant by hard-coded, yes, Twitter systems did apply those designations to those accounts. But it was seldom the case that Twitter staff would manually, individually go in and apply those labels directly.
Were any government officials, were those labels and therefore that filtering done to any government officials, any elected officials, where the user wouldn't know about?
I don't know, sir. I didn't have access to my Twitter computer, to any Twitter systems to prepare me to answer that question. So
I'm just talking your time there and your experience there. Do you know if that happened?
It would not surprise me to know that visibility filtering labels had been applied to the accounts of elected officials.
So visibility filtered labels applied to the accounts, but the user doesn't know.
Yes, it was not Twitter's practice to notify users.
But you think that happened to elected officials and government officials?
Again, I couldn't say for sure.
I appreciate it. I yield back.
Chair recognizes Mr. Mafume for 5 minutes.
Well, Mr. Chairman, it's been a long morning and afternoon. And at this point in time, there's an adage that says everything that can be said has been said, except that not everyone has said it. So if you will indulge me for a few minutes, I'd just like to reflect on some observations, having sat here and gone through this. And I'm hoping and praying that this is not a problem in search of a solution, because we're dedicating an awful amount of time here, and I don't want a few things to escape us. But having said that, I want to first associate myself with the remarks of Mr. Raskin, the ranking chair. His opening remarks succinctly, I think, encapsulated and put in place what many of us on this side of the aisle are feeling. And I also, as a point of personal privilege, would like to just express how many of us share the concern of the gentlewoman from South Carolina who indicated her ongoing medical condition, which she said she might have to live with the rest of her life. That just got me for a moment, and I wanted to make sure that that's on the record. Now, I would disassociate myself with her remarks when she said, as did the gentlewoman from Georgia, God bless Elon Musk. For me, it's God bless my country, God bless my family, God bless my friends. Mr. Musk can take care of himself. I would also caution, if I might, all of us, but particularly the gentleman from South Carolina who said earlier that there is proof that Hunter Biden committed multiple felonies. The gentleman said that without offering anything for the record. And I know we're all covered by congressional immunity in terms of when we're on the floor and when we're in these committees. But sometimes we probably don't want to feed into hot rhetoric. I mean, we campaign in that kind of poetry, but we are elected to govern in prose. And when you do that, there's a different sense of responsibility that goes with all of us. Mr. Roth, I listened to you and I feel bad that you were attacked. And, you know, you had to sell your home, you had to move your family. And I just want to remind you and remind myself that there are members of this committee who are also always under attack because of their race or because of their surname or because of their political affiliation. That kind of reckless incitement, I think, is best dealt with when you have content moderation. Otherwise, we gin up the rhetoric. The people who can't control themselves oftentimes don't, and then we see violence occurring against whether it's members of Congress through threats or persons like yourself in the private sector. Ms. Navaroli, you, in your testimony, stated that on the morning of January the 6th, that you sent lawyers a message warning them that your team was hamstrung by leadership. And 2 days later, when it looked like that might happen again, you asked management whether or not they wanted more blood on their hands. What was their response and what did they do?
Yes, thank you for that question. On the morning of January 6th, I did send that message to a Twitter lawyer specifically because I believe that Twitter was going to be facing liability for what was going to occur that day. I do not remember their exact response, but I do remember there coming in a response of confirming that the information had been received. Would you repeat the second question that you asked?
I wanted to know what was their response? What did they do?
Nothing.
Okay, you went on to say that in January